welcome to the 2025 Four Corners Family Law Case Update. I am Ryan Wedeking, co-chair of the Beverly Hills Bar Association's Family Law section. I will first note that our Family Law section is sponsored by White Zuckerman. White Zuckerman provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Learn more at wzwlh.com. We are also sponsored by SoberLink. As many of you know, SoberLink provides objective, real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. To help ensure smoother negotiations for a more efficient legal process, consider using SoberLink's trusted alcohol monitoring system to eliminate hearsay and protect your client's best interests. With an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, real-time results, and customized testing, SoberLink's discrete system has been the leader in remote alcohol monitoring since 2011. Learn more at soberlink.com. I will also note that we have an upcoming networking event tomorrow night at Above 60 Beverly Hills. That is a rooftop lounge and bar, very, very glam. And that is a cross practice group networking event with the entertainment law section and the estate planning section, which are two practice groups that you would all be well served to network with. So this is something that we're trying to do. We're trying to increase kind of cross practice group pollination this year. So we will see you all there tomorrow night at 6 p.m. Again, that's at Above 60 in Beverly Hills. Lastly, I will note that we have an upcoming CLE on March 11th that is on bifurcating issues of trial, and that is with Aaron Gray and Judge Luna. And with that, I will let Judge Silberman take it away with introduction for tonight's speakers.
Okay. Well, hi, everybody. Another year. And here we are again with our Four Corners program. I'm so glad to see all of you. And I know I get emails every year. You can't really see us, Judge. And I know that I can't really see you, but I can imagine. And I know you're out there. And I get to see some of you at my new gig at Signature Resolutions. Hopefully, I'll get to see more of you. But we're really glad to be here this year again. And I'm so delighted. Well, for those of you who don't know me, I'm Judge Harvey Silberman. I retired last year after 20 years on the family law bench, 8 years downtown, 12 in Pasadena. And I am so pleased tonight that I got our panel from last year all to come back. They're just so impressive to me, how intelligently they read and analyze these cases, that I'm just so delighted to have them. And as promised by the title of our program, they come from all parts of Los Angeles County. I work downtown in Pasadena, sort of centralized Los Angeles County, and as we had last year, holding up our eastern flank out in Pomona, we have Judge Janine Iriarte. We're so glad to have her back, and we have many thanks to her, all of us should, because we have the wonderful PowerPoint that she's mostly responsible for. So thank you, Judge Iriarte. Glad to have you with us. Then holding up our southern border down there in Compton is Judge Maria Puente-Poros. And I have to tell you a true story. This is an absolutely true story. I was so anxious to get Judge Puente-Poros on the panel last year that I tracked her down on her vacation and phoned her. She's like, "What are you calling me for on my vacation?" And I'm like, "I want you to do this panel." And she graciously said she did. And we're so glad to have her back again. And then finally, my oldest friend on this panel has been with me since the first years of it, Judge Amir Aronoff, our San Fernando Valley guy. And last year, I think, he appeared as Commissioner Aronoff. But this year, He's now Judge Aronoff, and we're awfully proud of him. I, of course, took the same route, commissioner and then judge, and so I'm so especially proud of Judge Aronoff. Okay, so we've got a lot of cases. We're going to do our best to finish in the 7:30 time slot. We'll do our best. If you have any questions, please put them in the Q&A and then they'll tell us. And hopefully we'll get to it. We always try our best, but there's a lot of material to cover. Okay, so if we can have the PowerPoint up, I'm going to turn the first case over to Judge Iriarte in Pomona and say, ready, set, let's go.
All right, our first case is in re Marriage of Patel. Now, I do have some facts up here, but this deals with legal separation. But I want to give you more background information regarding this case. Husband and wife were married in 2002. They had 2 children that were born in Georgia, Atlanta, Georgia. They moved to California from 2019 to 2023. In July 2023, the parties moved to Atlanta, Georgia. They lived in a condo that the husband owned in Atlanta, Georgia. The children were enrolled in school in Georgia, and the parties were looking for a home in Georgia. In December, the wife took the children to go visit the grandparents in California, and they planned to return back to Georgia in January of 2024. The husband joined them on that trip to California, and then husband and wife returned on January 8th to Georgia, but they didn't bring the children. Husband says, hey, wife kidnapped my children. Her and her family kidnapped them. And the wife said, no, that's not true. What happened is husband actually changed the plans. We were supposed to stay in California. Some important timelines in this case. January 4th, 2024, husband files for dissolution in Georgia with a request for custody of the children. January 11th, a temporary restraining order was granted against husband by wife based upon for domestic violence where she had requested custody, and that was done in Orange County. February 1st, wife files for legal separation, requesting custody. So husband files a motion to dismiss that legal separation petition and says, I'm not agreeing to this. And he says, based upon Family Code Section 2345, that the court may not render a judgment of legal separation without the consent of both parties. The trial court's ruling was that the trial court granted the motion to dismiss without prejudice to wife filing her petition for dissolution, quote, at the appropriate time. So the wife appeals, and her appeal argued that Family Code Section 2345 does not expressly authorize the court to grant a dismissal. So what does the Court of Appeal say? Next slide. The Court of Appeal affirmed the trial court, and they said Family Code Section 2345, a court may not render a judgment of legal separation without the consent of both parties. So essentially, by creating a condition to rendering a judgment of legal separation, that being the consent of both parties, Family Code Section 2345 impliedly authorizes dismissal if that condition has not or cannot be met. And then the Court of Appeal went further on to state that the trial court has inherent power to dismiss an action shown to be sham, fictitious, or without merit in order to prevent abuse of the judicial process. The Court of Appeal in this case indicated the record that the record did not reveal whether the wife had opposed the dismissal because she intended to amend her petition to seek a dissolution once she met the residency requirements pursuant to Family Code Section 2321 Subdivision A. The wife made a motion to continue at some point, and the reasons were to get caught up to speed and clear the jurisdictional issue. But the Court of Appeal again noted the request to continue does not mention anywhere whether the wife needed to meet the residency requirements, and that's why she needed a continuance. The Court of Appeal also stated whether upon a complete record we would have reached the same conclusion is a question we need not address. And I think in this case, the practice tip here is for appellate purposes, you really have to be ready to state the proper code sections you're objecting to. And don't count when you're going into court, don't count on the court granting your continuance. You still need to be ready and prepared with the arguments and code sections, because this may have ended up differently had the parties been ready. But I understand when you come in with a situation like this, where you have UCCJEA issues, you have, really, does the court have jurisdiction here? And you want to write a thorough points and authority, but you still have to be ready, because that court may not grant your motion to continue. And anytime you're on the record, it may not turn out the way you think it's going to turn out. So you always have to think, what do I need for an appellate record? And I tell you, for the way that I practice as a judge, it doesn't matter what case I have, whether it's a pro per, whether it's a lawyer case. Every time I make my findings on my case, I look at that case as though it's going to be an appeal case. So I try and make a very thorough record on every single case, just in the event it does go up on appeal. And I think if we have that type of mindset every time we enter court, we're going to be better practitioners or judges. Next.
Okay, good evening. And I also want to echo the gratitude to Judge Iriarte, because she is the architect of the beautiful slideshow that you're seeing. So
Well,
we're on to
everybody.
We're on to you versus Posniak Rice. And this is where the village gets involved, right? So this is a civil harassment restraining order. Petitioner is seeking a restraining order against their former partner's parent. And the issue here turns on the issue of what is sufficient due diligence for attempting to serve. And I thought it was interesting because as you can see, the declaration by the individual who was attempting to serve, Mr. Berdichevsky, he talks about what they try to do and how many times they try to do it. But the takeaway here is that you have to be finite with the due diligence. You have to be specific as to what you were doing. And sadly for the petitioner here, who was successful in getting in essence, a default restraining order, they were granted a 5-year protective order. The respondent files a motion to set aside. The court finds that the motion to set aside premise on 473 was not something that the vehicle that they could use, because there was no judgment entered. So the court denied it, and respondent Posniak Rice appropriately files their appeal. So that being said, the substance of the declaration for the process server talked about that they tried to ascertain addresses, and they used the email address from another court hearing from another jurisdiction. They used that address. They used the address from pleadings in this case, but no actual effort of them going out to try and serve the respondent. So the appeal is filed, and the Court of Appeals spends quite a bit of time trying to analogize and qualifying the distinction between due diligence and the meaning of the statute. In fact, they state with specificity, this case involves what showing is sufficient under the new statute, because as we know, the statute was amended 527.6 subsection M2 to include alternate service. And the court found that here, Mr. Berdichevsky just talked about efforts that they did to ascertain their address, but not actual efforts to go out and properly serve the respondent. So be aware that it's a diligent effort to find and to try and procure the individual, or locate the individual, not just the efforts to gain the address. There was a case that the court talked about, the Court of Appeals talked about, where an argument was made to serve by social media platform, and the court rightly points out that no e-service by media platform, although the times are there, that's not within the statute. So be mindful that you have to be giving the specifics. In fact, the reasonable diligence requirement in civil cases under CCP 415.50 is used to illustrate evidence required to obtain an order for personal service by publication. So they thoroughly vetted both options. And the declaration was deficient. There was no probative facts based on personal knowledge and demonstrating a thorough investigation to learn the respondent's whereabouts. In fact, Mr. Berdichevsky provided no information about his professional background and ID'd himself only as a, quote, service provider, end quote. There's no information about, is he an experienced investigator, or is he an experienced private investigator, a registered process server? What was his relative experience? So because neither party could explain neither Mr. Berdichevsky nor petitioner you or plaintiff you could explain what true efforts were made to locate the address for the respondent, the court found that the declaration was insufficient. Next slide. Next slide. My apologies, I forgot to have our folks supporting us to move the slide forward. And so there is the statutory information for you. Thank you. One last one.
I would add on that last case, while it seems very nichey that it's just about civil harassment restraining orders, 527.6 M2 is pretty much the exact same language for alternative service in a DV application. And so that case tracks specifically with what a court could do and should consider for alternative service of DV application. So I think that case should not be looked at as just the civil harassment context. But let's turn to Rinker. If you could just load up all of it, that would be helpful. So Rinker, that's great. Previously called Robert Winker versus Cindy Rinker. It was just recently republished and is now referred to as RR2 versus CR. So I'll refer to it as that case since they've anonymized the parties. This case is a common set of circumstances where mental health and issues regarding a party's mental health bleeds into the domestic violence context. We see a lot of cases in terms of people claiming domestic violence or alleging domestic violence when the other party is having a mental health crisis or attempting or threatening to attempt suicide as a form of domestic violence. And this one is very much focused on an individual who is in crisis but had a history of mental health crisis and engaged in problematic and frank and more transparently admitted conduct that would rise to the level of domestic violence, namely stalking and harassing, and conduct but for a mental health component would clearly be considered domestic violence. And what this court really focused on is the trial court's determination that imputing a level of intent in the conduct was how to gauge whether it was domestic violence or not. Specifically, the trial court said and essentially dismissed stalking allegations and harassing allegations as not domestic violence because there was no evidence that it was an intentional attempt to threaten or otherwise intimidate the party. Clearly not a requirement under the Domestic Violence Prevention Act, and the Court of Appeals did clarify that that element does not exist. But we often hear in evidence and evidentiary hearings on domestic violence a lot of focus on motive or were you really afraid? All these attempts to kind of impute some sort of expectation of additional elements to domestic violence. And I think that this case highlights that courts should not take that invitation to articulate domestic violence with some other expectation of evidentiary support. So I think that's really important about this case. But I also wonder, had the trial court found domestic violence and not made that asterisk for the intent and said, well, even though I see domestic violence, I'm exercising my discretion to not issue a restraining order because a restraining order would not meet the policy considerations for domestic violence given its mental health component. And for instance, it would not help to prevent further domestic violence, and that the issue of keeping the parties apart in order to deal with the underlying issues of domestic violence would not be met by issuing a restraining order. Now, if the court had exercised its discretion after finding domestic violence, I wonder whether the Court of Appeals would have overturned it. But in this case, the Court of Appeals really structured its analysis on the court added an element, intent, and that wasn't proper. And for that reason, it's reversed. But for that intent, the court found domestic violence. So rather than just send it back for the court to exercise its discretion, we're going to just issue the restraining order. So I think there's another element, and it was kind of a side issue, is this is the second appeal by involving this judicial officer with the same exact issue, and they brought that up specifically, that this is the second case that they're overturning based on this intent element. So I think that they really are sending a message, not just generally, but likely to the judicial officer, which happens. We get our comments, right? Next slide.
Okay, the whole slide, please. So this is a domestic violence case, but it's really important evidentiary case, really important. The wife and husband are married a short time, and they have a 4-year-old daughter who it appears is monolingual Spanish speaking or has limited English. The mother has 2 children from a previous marriage, including a 13-year-old daughter. The 13-year-old daughter accuses the husband of touching her breasts and inserting his fingers into her. And criminal charges are initiated against father, and the mother seeks a domestic violence restraining order, which would include custodial orders. The 13-year-old did not testify at the DV hearing. There was no evidence as to why, but wife's declaration states that the child told her of the alleged abuse and that she was present when the child was interviewed by the police, wherein she made the same allegations. The minor also told police and mother that the husband threatened to deport her and to falsely accuse her of stealing if she ever told anybody. So the husband's attorney objected to the admission of the statements by the minor contained in the mother's declaration as, of course, hearsay statements, and the objection was overruled. The trial court relied on a state of mind exception to the hearsay rules and found that wife to be a credible witness. Then the court took judicial notice of the pending criminal case against father and the CPO in effect. And it relied on Family Code Section 6306, which mandates that the court do a search prior to DV trial for felony convictions and other matters. Some of you may not know this. When we judges have a domestic violence restraining order, we've got to do a search, and we do. The trial court issued the restraining order, including mother finding that the husband disturbed her state of mind. It also severely limited father's visitation with the child of the marriage, the 4-year-old, until such time as she learned to speak English, where monitors can, in fact, understand and listen to the child and make sure and prevent any type of inappropriate contact between the child and the father. And the father appealed. And he says that the child's statements appearing in mother's declarations are hearsay. Any question that they were? The state of mind exception clearly did not apply to mother based on the daughter's statements, unless the statements were being made and admitted for the truth. But in a major shift, the Court of Appeals ruled that the child dependency hearsay exception applied. Now, many of us know that the rules in dependency court regarding children's statements are different than in family court, based upon case law that dates back almost 30 years. In certain circumstances, out-of-court statements by children where sexual abuse is alleged are admissible under this exception. The reason being that children may be afraid to publicly accuse a parent. They might be frightened of the setting in a courtroom or intimidated by adverse counsel or cross-examination. So the Court of Appeals stated that the hearsay exception applied in this instance, citing a California Supreme Court case which affirmed the exception based upon similar reasoning. The court went on to state that the same realities as we talked about in dependency court with sexual abuse allegations, the same realities exists for children in DV cases in family court, and the same reasons exist to protect them. And so the law is now, in DVPA cases involving the sexual abuse of a minor, otherwise reliable out-of-court statements made by that minor should not be categorically excluded simply because the statements do not fit into the traditional yet narrow categories of hearsay exceptions. So interesting to me was in response to the husband's objections about extending dependency rules into DVPA hearings, the court went out of its way to state that without limiting language by the legislature of other case law, rules from dependency court could be extended to other types of cases. Hear that? Without any limiting language from the legislature, we may be able to extend special rules from dependency court into family law. So in matters like Sanchez rulings, there's case law in dependency court which limits Sanchez rulings. Might that rule be extended to custodial cases in family court? Well, we shall see. I know I tried for years to get a case like that in front of me to test these rules. And I never got such a case. But after reading the dependency court rules on Sanchez, I was very interested in seeing it. Now we have a case where they've clearly said a lot of these dependency court rules really belong in family court as well. Just so you know, if you're trying to admit a child's statements pursuant to this hearsay exception, there are 3 requirements. First, the time, content, and circumstances of the statement must provide sufficient indicia of reliability. Second, the minor must either be available for cross-examination or there must be some evidence which corroborates the statements made by the child. And third, the opposing party must have had adequate notice that the statements would be introduced. As for the other things, the use of the criminal allegations as part of the pleadings, remember that you can only use things that deal with convictions and not just allegations. And of course, we all should know that a professional monitor must be able to speak the language of the party being supervised and of the child, or the monitor must provide a neutral interpreter over 18 years of age. Next slide.
Can I say something on that last one? I actually did a case more recently where I actually used this exception. And in my ruling, I actually took those due process requirements and I noted the age of the child, who the incident was initially reported to. I noted whether there was an indicia of reliability in that reporting, who specifically was it reported to, and I listed all the individuals. I think there were like 4 individuals that it was reported to. And then I noted that the child was actually at court in the hallway and prepared to testify. And then I asked the restrained party, do you have any witnesses that you want to call? They declined. And then I also noted that the relationship between the mother and father did not suggest that there was a motive on behalf of mom to fabricate and influence the child in any matter. So what I did in my ruling was I noted all those due process requirements, and I also showed that there was an indicia of reliability in the statement that was being admitted. And that's really what you want to do if you want to use that exception. You kind of want to set those things in the record. But on the flip side, if you want to keep the statement out, obviously you want to focus on attacking and breaking down those exact same areas. Oh, this is me. XK versus X. Okay. All right. So this is a case where wife was a Chinese immigrant, and I'm going to give you a little bit more background information. Her and her husband had 1 child. In 2023, wife filed for a domestic violence restraining order. Her temporary restraining order was denied. Wife claimed abuse dating back to 2016. There was a written apology in 2016 where the husband said, "I'm really sorry for not treating you right, for lying to you, for yelling at you," things like that. In 2017, wife said, "When I was 8 months pregnant, he grabbed me by my ankles, lifted me off the ground, and put me on the sidewalk." She basically indicated she was raped after she had the baby several times by him. In 2018, she was strangled in China with both of his hands. In 2019, she was punched in the shoulder and showed photographs of the bruising. And in 2019, the social media posts that you see up here, you think about suicide and I think about murder. He went on to say, "It's so wrong. We are general good people and deserve to be genuinely happy." She claimed to be emotionally and financially abused and placed under significant coercive control. I mean, it's to the point where she couldn't really even go to work unless the child was at school. That was the only time she was allowed. She claimed that she didn't even have a SIM card in her phone here in the States. And so she had no cell phone access. She claimed he was a harsh father and wouldn't play girl games with his daughter. Now, wife actually completed her PhD studies here in California. Now, the trial court in this case said that the vast majority of the discussions today has been around custody and visitation issues, and that is foundation of the dispute between the parties. And custody and visitation doesn't fall within the DVPA, therefore denied. Next slide. The Court of Appeals said, absent a lack of credibility finding, the trial court's explanation that the alleged abuse occurred in the context of disputes over dissolution and co-parenting and visitation was not a proper reason to deny. In other words, it was legal error to find that. And they also stated that abuse occurring in different countries must be considered under the totality of the circumstances. The wife asked, based upon this reversal, that the matter be remanded with the direction of the trial court to issue the restraining order. And the Court of Appeals said no. The trial court is best situated to exercise discretion in this case to grant or deny the DVRO. And this kind of goes to what Amir was saying earlier. You know, what would happen if the proper finding had been made? But anyways, the trial court is best to evaluate credibility of the parties and weighing of the evidence. And in this case, all over this decision, the Court of Appeal talked about credibility, because I think the Court of Appeal could read between the lines in this case. I mean, the initial TRO was denied, and I think that they could see that there were a host of grounds that this woman brought forward. And I think there were credibility issues in this case. And I think the practice point for us is when you have a case like this where there's all kinds of very serious allegations and the court makes a finding like this, like, oh, this is just custody and visitation, you need to step back if you just won that DVRO, and you really need to, because you know it's wrong. You know that it's going to go up on appeal and it will be reversed. Okay, we know that. So what do you do in a situation like that? And I've always said time and time again, you need to be prepared, even in renewal cases, with the law in your case file, so that if a court does this, because remember, the courts are busy, all right? We have a lot of restraining orders, a lot of matters, but take a step back and say, Your Honor, can you please make a credibility call in this case? And then if it's not on credibility, I would have the court actually look at the law and give them the case. And say, for appellate purposes, Your Honor. And when you say for appellate purposes, that's going to go ding, ding, ding in the judge's head. I need to make a better record so I don't get reversed. Because I can tell you there's no judge that wants to get reversed. So help the court along, ask for the break and give them the case law. Next slide.
Okay, following along the domestic violence, the issue of coercion and control. This case is relating to a woman who was 26 years old when she met this individual. He was 42. And so, of course, there's an age difference, and he was a human trafficker. And he took her from Honduras and then into Mexico. And in Mexico, she tried to escape, and he threatened that if she ever left, he'd kill her, right? So she's not there of her own volition. When the case comes to be, they have three daughters. They have a 6-year-old, a 5-year-old, and a 4-year-old. So I want you to keep that in mind as we talk about a little bit about the facts. There was the cycle of violence that included the alcohol abuse by the perpetrator, the isolation. In fact, when he brought her to California, he put her in the middle of nowhere. And the middle of nowhere is in quotes within the court's opinion. And she's in his trailer, and it's just her and the kids. She can't go to work. She can't go run errands. And he is 100% the provider. So she's definitely at his um, beck and call, and of course, beholden to anything that he decides. She gets pregnant, and within 2 months of the child's birth, she's pregnant again, but she had gotten on birth control. So at one point, she mentions about the birth control, and he says, well, yeah, I swapped the birth control pills for vitamins, right? Because he wanted her, quote, to have as many babies as they could so that no man would ever want her. So again, this continued cycle of violence, both situational, physical, emotional, mental. And in the existence of this, quote, relationship, there's beatings, there's rapes. In fact, one of the rapes happened with the 2 children in the bed, at least as reflected in her declaration. So at one point, she hides her smartwatch so that she can, because he comes in and he's attempting to assault her, she hides her watch so that she can call for help. So the next day she calls 911, police come, they arrest him. So she goes with the children to Texas, to her aunt's house. He gets out of custody. He doesn't know where she is, of course, because she's not disclosing it, but he gets access to her Facebook and starts to change the password and starts reading her messages and realizes where she is, so identifies her home address. He goes to the home address and somehow entices the 6-year-old to come out. Now, mind you, she'd secured a restraining order, and he wasn't supposed, and there was that criminal protective order, right? That emergency protective order, and he wasn't supposed to be reaching out to her, but he does. And he continues to show up at her address in Texas. He coaxes the 6-year-old to come out, and then, of course, she feels, at least in her testimony, that she had no other option but to allow him to see the kids. So she allows him to see the kids, and then he takes off with them. He takes them to California without telling her. Then he takes them to Mexico, and for 7 months, she's trying to get her children back. She files her restraining order, and the temporary order grants her protected status, but not the children. And the basis for the denial on that was that there was no imminent risk of harm to the children. So they go to a hearing, and she testifies to all of these atrocities that she's undergone. And there was testimony that he'd actually hit the children, not sexual abuse, but physically abused the children. And the court denies. The court allows them to reopen the testimony. There's a great deal about all the machinations with the declaration and what I have and what I don't have, at least from the judicial perspective. And then the court at the end denies the protective status to the children, but finds that there's a basis to grant it as to mom. So mom appeals. And the court says specifically, right, there's good cause, and you have to look, as Judge Iriarte just mentioned in the prior case, at the totality of the circumstances. So if you think about this adult person that can't protect themselves, and you have a 6, a 5, and a 4-year-old who are in the presence of this environment, they are witnessing it, and they can't protect themselves. So the court then, of course, reverses and says, right, upon a showing of good cause, witnessing a parent's abuse, but they themselves are also abused. They're watching these things during a rape. One of the children wakes up and is crying and is saying, "Leave my mommy alone," right? So the court then reverses and remands with instructions to include the children as protected parties. Thank you. Next slide, please.
All right. We can put the whole slide up. This is actually an interesting DV procedurally case because it deals with the issuance or lack of issuance of the TRO. And this is an appeal of a TRO determination. And what's interesting about it is you wonder why the stakes are so high to engage in a litigation over the issuance of a temporary restraining order when there's subsequently a hearing to decide whether there will be a restraining order at all. So for someone to go to the lengths of appealing that is interesting, but actually it ends up being a very helpful case to give some insights into judicial obligations as it relates to the decision to issue or not issue a TRO. And in this particular case, wife comes in and there's a high asset case where they had signed a marital settlement agreement, and she proceeds to indicate that conflict between her and the husband continues to escalate, in part because of the marital settlement agreement. There was harassment, coercive control, arguing over the MSA and following the MSA, and engaging in essentially quid pro quo kind of discussions as you better do this, otherwise you're not going to get the remaining $5 million of our settlement agreement, and so forth. And she brings this TRO, and the court that was reviewing it, and keep in mind that some of us are reviewing between 5 to 10 TRO applications every day. So we rely very much on these check boxes that exist on these TROs. And this judge also issued a text, checked the boxes and indicated that they believed that there wasn't sufficient evidence of abuse. And the other checkbox, there isn't sufficient detail as to the abuse. And that's where, and then also issued another one saying this is custody and visitation issues and conflict over an MSA. So the interesting part is the Court of Appeals in this, what looks to be like the first case relating to the issuance or the decision to not issue a TRO, really focuses on what those text box means, and essentially assesses that those text boxes were what the court determined, but that was not true because there were clearly enough evidence of abuse and sufficient detail. So for that reason, it should be reversed. But it also gave us, for the first time, language that a court could use, even if it finds a facial showing of abuse, to decide not to issue a TRO. And they gave us verbatim what we are able to say in exercising that discretion, is specifically indicating that under the totality of circumstances, the court finds that the party has not demonstrated the need for a TRO to prevent abuse pending a noticed hearing. And the Court of Appeals specifically indicates that that would have been perfectly fine. And the court even, and often judicial officers complain that the Court of Appeals doesn't understand, especially in the DV context, the inner workings and the realities and logistics of DV litigation. But actually, this Court of Appeals acknowledged that there's a lot of reasons why you would deny a DV TRO, that there's the context of using it for tactical purposes, and why sometimes, because it's an ex parte application, and where it is in the process of a case, that it may be more thoughtful and prudent to wait for the hearing. So had the trial court said that, there would have been no issues. And thankfully, this judge didn't do that, so that we can get specific instruction from the Court of Appeals that we can do that we can deny it. And I think that this often comes up in the context of, for instance, long-standing litigation, very heavily litigated, and all of a sudden an ex parte application for a domestic violence restraining order comes, and this feeling that the court is compelled not just to issue a temporary restraining order without notice, but also issue custody and visitation orders, etc. And I think that this case highlights that a court is allowed and should consider the context of the application. And even if otherwise it would have, in a different context, issued the restraining order, in this particular context, it can decline and wait for the noticed hearing. I think that's really powerful to understand the level of discretion a court should engage in, even on what would otherwise be garden variety TRO applications. And so, we hate to see that certain applications come only to find ex parte applications thereafter, or a responsive TRO application also ex parte without notice. If I think the idea might be that in the context of a heavily litigated proceeding, giving notice, even though you're not required to, in the context of a DV application, goes to that totality of the circumstances for a court to consider, as opposed to don't give notice, even though you know the other side has been litigating and has counsel, but for you not giving them an opportunity to respond, the court only gets one side, right? This is an invitation to really think about context and give the court some leeway to gauge the context of a DV application. So I think there's a really good case from a judicial standpoint, and also a warning to practitioners to really think about not just the application as that one ex parte, no notice application to get some sort of advantage, because it may not necessarily end up that way, because this case tells us to consider the totality of the circumstances, even at the initial application. Next slide.
Okay, Hart versus Hart. So this case, just a little bit of history. The DISA was filed in 2017, and very quickly thereafter, the competing restraining orders are filed, one by Ashley, one by Stephen. It took several days of testimony, and the hearings conclude in February of 2018. Stephen's is denied and Ashley's is granted. And then, of course, thereafter, they come to a stipulation in July of 2019, and Ashley stipulates to dismiss her protective order with prejudice. So things are moving along. And then July of 2023, Ashley has to file another restraining order. And of course, the court, I don't mean, of course, obviously, I mean, thereafter, the court grants it. September of 2023, she gets a 9-month protective order granted in her favor. Within the statutory time period, she files her request to renew it, and the court conducts the hearing, and she's asking for a 5-year renewal. The court does the hearing and says that they're not inclined to grant it for a 5-year period, but they're inclined to grant it for 9 months. Just a repeat of what the DB 130 that was previously granted in September of 2023. And the Court of Appeal says, yes, the court has judicial discretion, right? There's discretion of the court. However, this is pursuant to Family Code 6345A. This is a minimum term period. So if you find that there's a basis, the judicial discretion is out the door, and you have to grant it for the renewal period, which was 5 years, 5 years, more, or permanent. So those are the 3 options. So be mindful when you are filing for your renewals, quote the statute. And this is not in any way, shape, or form other than to say, help the court, just like you would provide your memorandum of points and authorities. Sometimes these particular renewals are so few and far between, right? So just couple blurbs in your declaration, your prayer for relief, pursuant to Family Code 6345A. The court's 3 options are just anything to kind of highlight it, because sometimes we are navigating family law, dense issues with custody and support, and this is a one-off from everything else that we're doing. So help us help you to get the movement that you need us to get you to, if, of course, your client prevails based on the evidence. So that, and then I want to double back with what Judge Aronoff said, professional courtesy and the professional responsibility, I think, though you can go in with no notice, should you, is one of the questions you should consider, so that we can get contextual pictures of the entirety of the case, especially in these very highly litigated cases. Thank you. Next slide.
Okay, whole slide. Marriage of JG and KG. Family Code Section 3044. Ever heard of it? I think we all have lots of appeals court cases on this. And this is another case, really, it's instructive to the judicial officer. So why do I'm an attorney? What do I have to listen to that for? All right. Well, I think as Judges Iriarty and Aronoff have spoken about, well, because if you're getting a ruling that's in your favor, you want to make sure that all these things are covered so that it's ironclad and you don't get a reversal. And that's what happened in this case. As most of you know and understand, Family Code Section 3044 creates a rebuttable presumption stating that after there's a judicial finding that a party is a perpetrator of domestic violence, with or without a restraining order being issued, it's presumed that it's against the best interests of the children related to the case to award the perpetrator joint or sole custody of the child or children. The courts have been pretty clear that you cannot get around 3044 unless there is a finding by a judicial officer on the record that the presumption has been rebutted so that the court may find it is in the best interests of the related children to award the perpetrator sole or joint custody. So at the initial trial stage in this case, the court found that there was domestic violence. It had been perpetrated by father against the mother. However, the parents made an agreement to share custody of their child, and the judge, without making any inquiries or findings as to 3044 being rebutted, signed off on the joint custodial judgment. A few years go by, and the mother files a motion. I guess things didn't go so well. She files a motion to modify those custody orders and give her sole custody of the child. Now, there's a new judge who's now on the case, and this judge was clearly aware that 3044 was in play, but the only evidence taken was father's verbal assertion that he had completed an anger management class. Father's attorney did not bother to produce a certificate of completion or any other corroborative evidence of father's completion of the class. The case got sent down to the court mediator. Now, El Dorado County, where this has happened, is what we call a recommending county. And the court mediator recommended to the court that the current shared custodial schedule be retained, despite the mediator's admission that there was no evidence presented to the mediator as to things father had done to rebut that 3044 presumption. Father argued that after 2 years of joint custody, it was unnecessary for him to show completion of his anger management program or any other program he might have taken. Despite the lack of evidence, the court found that 3044 had been rebutted. The court also noted that the joint custody order had been pursuant to an agreement of the parties. Finally, the court stated it was troubled, not by the lack of evidence as to rebuttal. It was troubled by mother wanting to go back on an agreement she had previously made. So, as most of you hopefully know, neither the initial judge nor the second judge fulfilled the court's mandatory duty in finding the 3044 presumption had been rebutted. While the first judge was free to adopt the parties' joint custody agreement, the judge had to first take evidence and make findings that the 3044 presumption had been rebutted. The second judge seemed to understand that 3044 was still in play, but merely stated that it had been rebutted without identifying when or how the presumption was rebutted or address any of the factors outlined as possible reasons for rebuttal or state any of it on the record or in writing, which is mandated by the statute. So what else does this case remind us of? The parties cannot merely agree to waive or somehow get around 3044. Prior to adopting such an agreement, the court has to make findings that 3044 has been rebutted and state what evidence they use to make those findings. The best interests of children trumps any agreements by parents, at least in this setting of 3044. The health and well-being of the child has the greater state interest than any agreement by the parents. Next slide.
CT versus Superior Court. Next slide. Okay, so the trial court in this case granted a 5-year DVRO and continued temporary co-parenting orders. This case was actually filed in 2019. And in 2024, CT requested to relocate to Denmark, and the court maintained orders and then set it for a future final custody determination. And at a hearing in August of 24, the San Francisco Superior Court found that neither the child, CT, nor KW resided in California, but noted that the court retained jurisdiction over the ongoing custody case. So CT challenged this decision, arguing that the court lost jurisdiction under the UCCJEA. And specifically, what CT was arguing was Family Code Section 3422, which states that a court in this state has exclusive continuing jurisdiction over the determination until either of the following occurs. And one of the occurrences is in Subdivision 2, which states that a court of this state or another state, when they determine that the child's parents, or any person acting as a parent do not presently reside in the state, then the court loses jurisdiction. So that it went up on a writ, and the trial court retained jurisdiction to resolve the original co-parenting and visitation issue, which was filed in 2019, despite the parties' relocation. Jurisdiction attaches to the commencement of the proceeding and is not lost due to the subsequent relocations. So really, what happened in this case is Family Code Section 3422 is normally addressed in the context of a modification hearing after final custody and visitation determinations have been made. The scenario we have here was a filing in 2019 that remained open with no final orders or judgment. And so the court said, while the case is proceeding and pending, and the court has not resolved it with the judgment, essentially, the court still has jurisdiction. And the Court of Appeals said, that makes a lot of sense, because if you think about it, a contrary interpretation would lead to forum shopping. It would lead to the parents deciding where the jurisdiction would be held, because if they didn't like the judge's rulings, they could just move. So the Court of Appeals said, yes, you still have jurisdiction. In a footnote, the court did say that CT would be free to file a motion under Family Code Section 3427 for inconvenient forum, but states we're not going to make a comment as to how we would rule on that. Next slide.
Okay, marriage of RK and GK. So this is a due process and an appellate issue case. The Court of Appeal indicates in its opinion that there are two things that you should be focusing on. An appellant affirmatively has to show an error by referring to an adequate appellate record. Here, there was no appellate record. And the second general rule is that the appellate court cannot consider a claim of error that could have been, but was not raised in the trial court. Here, Dad failed to raise the issue that he was asking the court to consider. He had custody of the minor child by virtue of an MSA. Mother, he then moves away from the county where everything was adjudicated. He moves away, and then mother files a request for joint custody. So, of course, notice on the custody issue being at issue, and the court rules that mother will have custody of the minor child, and father appeals saying that it was a move away. But remember, he's the one that moved away, not mom. And so the court, in essence, based on the fact that he was found to be manipulative and certainly not credible, the court found that mother's request for physical custody put him on notice on that being the issue, because of course he then lost custody. It was a 3-day evidentiary hearing. So be mindful, right? That father's claim based on his position that he didn't know mom wanted her to come back to the county where all of this originated was disingenuous. So you take, again, the totality of the circumstances, the witness, their testimony, what they put in their paperwork, and also, most importantly, what record is or isn't created. So be mindful with your settled statements. If you don't have a court reporter, if you can afford a court reporter, get a court reporter. If you can secure a court reporter provided by the court, do what you need to do. But it's really important that you understand we're doing less with more, so you're going to have to be very creative on how to make your record. Next slide. Oh, I just want to point out that the court affirmed the Court of Appeal affirmed the trial court, and the minor was allowed to remain with the mother as granted by the trial court. Sorry about that, Judge Aronoff.
No worries. So, Balandron is a case where we can all say on the whether you're in the on the bench or you're a practitioner, really highlights, I think, one of the most difficult set of circumstances to navigate, which is grandparent visitation when one of the parents is deceased. And what Balandron does is it highlights that difficulty and that tension that exists in these types of cases. The well-meaning desires to try to find a solution for children in a really unfortunate set of circumstances, and then the constitutional issues that are implicated by those desires to find some sort of harmony. And Balandron, like a lot of these grandparent visitation cases, really focuses on the constitutional rights of parents and how the court needs to really delicately balance the issues of fitness, the issues of detriments to children, and all of the factors to consider before issuing a grandparent visitation order over the objection of a parent. Because the courts time and time again have highlighted the importance of giving the special weight to a fit parent's decision, especially in the context of parents who are willing to give at least, they say so, and they show it demonstrated to some extent, unstructured visitation or access to children by the grandparents, and their desire to not be bound by an order. So Balandron is really not unique in its assessment of the factors to consider under Troxel and 3102. What I think it highlights again is even the Court of Appeal, time and time again in its decision, talks about this difficult tension of or the invitation, especially by grandparents, that the court essentially assess its values of what would be appropriate given the circumstances over a parent's value system. And we have to defer again and again to what otherwise, in all the reasoning that a fit parent might have to deny visitation or structure it in the way that they want, without falling prey to, frankly, the emotions that are so involved in these cases, and the attempt that often some of us on the bench try to do is find some sort of commonality and perhaps a solution. And sometimes the solution is we can't wade into it. And sort of Balandron just says, thank you for your attempt. Just stay out of it, which is not a very satisfactory kind of solution when you're dealing with a dead parent, grandparents that are the only connection to that dead parent, and another parent who is not necessarily the most reliable, but still fit. So another one of these cases chalking up the grandparent visitation conundrum. It really is a conundrum, and there are cases previously that just talked about it very aptly as one of the most difficult judicial determinations to make. And I think this case highlights that again. Next slide, please.
Okay, in re marriage, Alan Freeman. Freeman, not to be confused with other important family law appeals cases with the same name of Freeman. So I guess if your name is Freeman and getting divorced, don't appeal anymore. We have enough Freeman cases. But this is a typical fact pattern. Couples married 20 years or so, no minor children. There's a request for spousal support and a determination of the community interest in a separate property home. So, 14 months ago during my last days on the bench, and even now in my capacity as a private judge, when hearing spousal support cases, the pleadings often appear to put the marital standard of living front and center. And I understand that it's one of the 4320 factors for which the court must make findings. However, if you really take a look at the case law, which I went back and did over the last 20 years or so, it appears to me that marital standard of living has lost a lot of its determinative power. I mean, it's still there as a factor, and perhaps in some cases a major one. However, this case, the Freeman case here, certainly focuses more on ability to pay, health, the age, and I think significantly employability, not simply based on a vocational evaluation, but seen in light of the health, the age, and all the other 40 through 20 factors. Also, the court makes a point of asserting its right to make basically whatever spousal order they wish after properly evaluating all the 4320 factors. In other words, there's no formula. Importantly, it is the court that determines which of the factors take priority. You can argue the various factors, but it's the court that prioritizes. So I think that a mere reliance on the marital standard of living is a questionable tactic. Again, support your case, yes, but reliance on it, I'd be careful. Importantly, we all know that disamaster or ex-spouse may be used in calculating a temporary spousal support order, but cannot be used to calculate a permanent order. That is where analysis of the 4320 factors must be determinative. For years, I would make it clear as possible, that I was segregating any disamaster calculation used to temporary support when doing my permanent support calculation. However, we would often still use the program to calculate important things like net spendable income, various tax ramifications. Well, that is what happened in this case, as ex-spouse was used simply to supply the court with certain financial factors, which the appellant believed was an improper use of the program. The Court of Appeal importantly said it was not improper. The judge properly covered the court by including detailed findings on all the 40 through 20 factors and detailing the findings on each factor. And the Court of Appeals made it clear that this was sufficient to answer any questions regarding whether the court improperly used the ex-spouse temporary order. I used to have the 40 through 20 factors on the bench with me, and in every case, I simply went down the list. Judges and lawyers, if you want these kind of rulings to withstand scrutiny, make sure the bench officer makes findings on each factor. That will bulletproof the ruling, even if the ex-spouse program is used to calculate financials or net spendable, or even as in this case, the temporary order is referenced in the ruling. Additionally, the family residence was a separate property residence, which had accumulated a significant community interest over the 20 years of the marriage. As you all know, we use Moore Marsden to calculate such a community interest, and we need a valuation of the property to correctly calculate that interest. In this case, the value of the property was significantly higher on the date of separation than it was a few years later at the time of trial. The court validated what I believe we all know. Generally, property is valued at the time of trial. If the litigant sought an alternative valuation date, they needed to file a motion prior to the trial. Next slide.
Marriage of De Benedetti and Ensberg. If the name Ensberg sounds familiar, Morgan Ensberg, it's because he's a Major League Baseball player, third baseman, and he played for the Houston Astros along with another team. So this case deals with 4 retirement accounts. Next. So in 2018, there was a stipulation dividing half of the community property interest in his Houston's Astros 401k. Wife received her half, and the balance was husband's separate property. 2019, there was a status-only judgment. Next. 2019, again, another division of a pension. Next. In May 22, there was a trial on reserved financial disputes. Next, the trial court ruled that, again, now this is the third pension, that the court is equally divided, but the court at this hearing found that there was a breach of fiduciary duty to the amount of $3.6 million and awarded 1.8 to the wife, 230,000 in attorney's fees, 100,000 for breach of fiduciary duty, and 130,000 for evasive interrogatory answers. So the wife was awarded over $2 million. Next. Now, fast forward in the case. The judgment is entered in this matter. And then, go ahead, next. And then the wife thereafter, several months later, files a request for order to enforce the awarded $2 million by 4 Quadros, making her the sole beneficiary of all of the retirement accounts. So there's now a 4th retirement plan from the Tampa Bay Rays that he had acquired after separation. The trial court's ruling did grant signing the 4 Quadros, giving wife 100% of the benefits, which really didn't even secure for her all the money that she had lost and was deprived of. The Court of Appeal held that the Quadros related to marital property rights and complied with ERISA. The Quadros are a proper vehicle to enforce damages for the breach of fiduciary duty. Next. And looking what the court did in this case, let's first look at husband's arguments. He argued, number 1, the Quadros didn't relate to marital property rights. 2, it contravened ERISA. And 3, the Quadros were invalid because of certain code sections, but also the trial court divided marital property after the final disposition of the judgment. Next. Next. Okay, so ERISA generally prohibits assignment of or garnishment of retirement plan benefits. However, next. The exception would be for a Quadro, which protects the rights of non-employees. Next. To qualify as a Quadro, the order must relate to the provisions of child support, alimony payments, or marital property rights. And the question in this case was does enforcing the breach of fiduciary duty reimbursement of lost community property create a marital property right, which can be enforced through a Quadro aimed at separate property retirement accounts? And the answer is yes in this case. So if we go back next, if we go back to the husband's arguments, the court said, no, we're saying this is marital property rights. So no, you don't get that. The second argument was it contravened ERISA's purpose of protecting the retirement account. Now, in this case, there's an interesting argument about the Marshall case, which the court had denied, where a wife did not get some money out of a stipulated judgment to pay a tax liability. And the wife tried to use the Quadro to get that. And the Court of Appeals said, no, you can't do that. So the husband was trying to say, hey, look, that applies. And basically, the Court of Appeal in this case distinguished Marshall and stated the husband's duty in the Marshall case to hold the wife harmless regarding that stipulation was because the husband assumed to do it. And the underlying liability was not the wife's, rather it was owed to a third party. And so in this case that we have here, the Court of Appeal said the obligation of husband was a breach. And again, they keep going back. It's a breach of fiduciary duty reimbursement, which is a marital property right owed to wife as a portion of her community interest. Going to the third argument, there were these 2 sections, 2610 and 704, where the court said, look, ERISA preempts that. But I want to look more at where the trial court divided the marital property after disposition. I thought this was interesting. The Court of Appeal said the trial court did not modify the existing judgment by issuing the Quadros. The Quadros merely allowed wife to enforce the existing judgment regarding her marital property rights against the retirement accounts. There was no second division of property or modification of the judgment. So as to that third argument, the Court of Appeal says no. And we all know where this goes from here. 3 strikes and you're out. Next.
Okay, marriage is strong. Another issue on enforcement of judgments. This is an arrears issue or an arrears case where we're talking about reach and where can you reach to get your collections. So Mr. Strong was in debt to wife to the tune of $2 million. That was what he was in arrears for both child and spousal support. And he admitted he had no other assets to make good on this debt other than the copyright to these Michael Jackson works that were titled The Collected Works of Jackson Strong Alliance. And so he's arguing, look, we know, court, that you can reach a patent, but you can't take my copyrights, because wife had filed an RFO seeking a receiver to monetize this copyright privilege or right that husband has. And husband's argument, again, is yes, you can do that, but not for, you can do it for a patent, but not for a copyright. And the Court of Appeal and the trial court affirmed the Court of Appeal affirmed the trial court when the trial court found that pursuant to CCP section 695.010A2 provides that absent any exception, quote, all property of the judgment debtor is subject to enforcement of a money judgment, end quote. So husband could not carve out this copyright. There was no statutes. In fact, there's no statutes on the copyright. It just mentions the intellectual property. So Mr. Strong was, of course, unsuccessful. Wife's claim and RFO was affirmed. And so therefore, again, be mindful of the statute. And if there's nothing that prevents it, right? Then that's the theory that you hang your hat on, as Mrs. Strong did here and was successful in collecting her $2 million. Thank you. Next.
All right, on Nelson, it's a case where an individual really believed their legal argument. And unfortunately, the Court of Appeals found it to be without merit whatsoever. This individual, was a very high net worth individual, was ordered to direct his trust to provide security for a significant $20,000 a month spousal support obligation to a spouse that was much younger than him. And he argued to the Court of Appeals and the trial court that making me set up a trust to secure the spousal support when I'm dead is the equivalent of violating the statute that says spousal support is not payable once I'm dead. Very novel workaround kind of argument. And the Court of Appeals pretty much says, not only are those statutes appropriate, you're reading it wrong. The security is established during your life. Had it been established after your death, perhaps you'd have weight. But the court has the ability to order you to provide the security after it made detailed findings during your life that will be payable to the other person upon your death. That's not the same as ordering you to pay when you're dead. So interesting kind of trying to turn statutes and trying to find disharmony where there wasn't a lesson in, you could shoot your shot, right? Shot it all the way up to the Court of Appeals, and the Court of Appeals said no and said, go ahead and pay all costs for the appeal. And likely he probably paid for all the attorney's fees to get to the Court of Appeal, I suspect, given his net worth and the disparity in access between the parties, which led to the security. So we never know what the next chapter is, but you shoot your shot, but probably had devastating consequences on the back end. Next.
Okay, an unmarried couple have a child together. Father's a member of the Chumash Indian tribe, and both parents worked at the Chumash Casino Resort. Following the breakup of their relationship, mother files a request for child support and attorney fees. As a Chumash descendant, father received $5,000 a month from the Chumash tribe's general welfare program. The question brought to the court was whether this $5,000 monthly payment from the general welfare program was to be included as money available for support, as well as included in the calculation of a contributive share of attorney fees. His attorney, who was also the tribe's legal and governmental affairs officer, claimed without any corroboration that the general welfare payments to tribal descendants was in the form of just that, a welfare payment, and therefore not subject to federal taxation, nor to inclusion as income available for support. Now, as most of us know, there are governmental benefits that are included in income available for support, such as Social Security, pensions, unemployment benefits, workers' comp benefits, and indeed, many tribal benefits have already been litigated in this area, such as reasonable value for rent-free housing on a reservation, and things such as that. And they've already been decided that they are indeed income available for support. But what about the tribe providing, as in this case, what the title suggests is a welfare payment? Well, Family Code Section 4058 precludes a court from determining child support by including as income payments a party who receives from any public assistance program, eligibility for which is based on need. That is why when calculating child support, we do include SSI payments or general welfare payments that provide a minimum level of income for the indigent and other categorical assistance programs for the poor. Most, if not all, of these programs must meet the federal and state poverty levels to qualify for the benefits. So, are we to look at this tribal so-called welfare program as a measure to assist the indigent and therefore exclude the payments from the support calculation? I think the answer came pretty easily once the court reviewed father's income from his tribal job working at the casino. His base salary was $114,000 a year. And the court found, therefore, that the tribal welfare program, despite its name, was not a program designed to provide minimal assistance to the indigent. The $5,000 per month, $60,000 a year, was properly included in the trial court's calculation as in for support, and the attorney-free order was proper due to the court's consideration of this additional income. Next slide.
Marriage of Ade and Faramay. In this case, it's looking at the I-864 affidavit for support, which is an affidavit that a person needs to sign with the U.S. government if they want to sponsor a family member to get their green card. And doing so, they have to basically promise to provide sufficient income and assets to support the immigrant. And basically, the primary goal is to assure that immigrants do have enough money to support themselves and really not live off of the government. And the obligation generally lasts until the immigrant naturalizes or earns 40 qualifying work hours, which is about 10 years. So in this case, husband had sponsored wife, and wife files an RFO for spousal support based on the I-864 affidavit. And this is a case of first impression for the Court of Appeal. So wife argument was that the federal poverty guideline in 2024 was $15,060 per year, and 125% of that is $1,569 in spousal support per month. And wife said husband had to pay that until she became a U.S. citizen. Well, husband in this case argued, hey, look, wife earned $57,900 in 2023, more than the 125% federal poverty guideline, and argued wife's income should be considered. Well, the trial court actually ordered the $1,569 and ordered that it would be paid until the wife reached her 40 quarters, which would have been approximately 10 years under this program. So what happened was the trial court was reversed, and the Court of Appeal said, look, you need to go ahead and consider that income. And they basically interpreted the I-864 quote, had to provide any support necessary to satisfy the minimal requirement, which necessarily requires consideration of the wife's income. And it makes sense, right? Next.
All right. Kuvabina, I'm sure that most of the lawyers listening have faced a litigant like the appellant in this case. And most, if not all, of the judges listening have faced a litigant like this. This is an appeal from an order finding that mother in this case was a vexatious litigant. Thereafter, she needed to file a request for the supervising judge at the court overseeing the case to review any moving papers and approve the matter to go forward before the trial court could proceed with the matter. CCP Section 391 et sec is the code section governing the vexatious litigant findings. In this case, in the 5 years prior to the action, mother, who was an attorney representing herself, had commenced, prosecuted, or maintained 11 appeals and writs 9 of which had been finally determined adversely to her, with the other 2 still to be ruled upon. So the vexatious litigant statutes are designed to protect opposing parties harassed by meritless lawsuits and to conserve court time and resources so as to protect other litigants who are waiting in line for their legal cases to proceed. To qualify, a self-represented person has to have filed at least 5 qualifying pieces of litigation within the past 7 years that were decided adversely to them. Remember, in this case, she filed 11 writs and appeals in just 5 years, so she qualified. And just to prove how vexatious she had become, most of the rulings found in the appeal opinion were things that were already legally clear. There was no question for the Court of Appeals. So first, she claimed that appeals don't count towards the total number of actions she brought forth. Well, there's a ton of case law making it clear that appeals and writs do count. Then she argued that her appeals don't count because she was defending herself against actions brought by father. Her appeals and writs were not deemed to be in defense of herself just because she was appealing rulings that went against her. So that argument was blown off. Then she argued the 4 writs she filed, attempting to disqualify various judges, were not final adjudications and therefore not part of the number of litigations charged to her. And they were not final because the litigation kept going. Well, the court said, no, the issue of whether the particular judge was biased against you was final. Then she argued that because she had been denied an attorney fee order and was forced to represent herself, she should not be charged for her actions because she didn't know what she was doing. They didn't buy it since if you choose to represent yourself, you are held to the same standards. And finally, she argued that because the court maintains jurisdiction in custody and support cases, that her appeals on those matters were not final adjudications. No, the court of appeals said, as to the particular orders appealed, they were final orders, and she met the standard, and she was a vexatious litigant. So just be thankful that you do not run across such a litigant, and know that these rules should be in your arsenal should you have to defend yourself. Next slide.
All right, for our final case, we have Goldman, which I think is a good backstop to the cases relating to enforcement authority and how far enforcement authority goes. And this talks about specifically about the issue of defenses to the enforcement of a judgment when a party delays and does not actively pursue enforcement until years and years later. And opposed to the last case I presented on relating to a frankly unreasonable interpretation of 2 statutes, this case really turns on 2 reasonable interpretations of the same statute, so much so that the Court of Appeals had to look into the legislative intent to understand whether the legislature even considered equitable defenses when it comes to pursuing enforcement of judgments in the family law context. And they came to the conclusion that other than some categories of enforcement action, specifically on the issue of support, where the equitable defenses are not available in the context of money judgments and property judgments, there is the ability to assert equitable defenses. And the question was whether the equitable defense of laches applied in a case where wife waited for over a decade to pursue her claims under a judgment, to enforce the division of certain assets, and to, in this case, also seek the filing of joint tax returns and exchange of refunds. So she sat on her hands for a while. And while the court did say, yes, this laches issue does apply in this context, it highlighted what needs to be proven in order to establish a defense of laches, namely the failure to assert a right, for some appreciable period of time, so as to the amount to amount to unreasonable delay, and the result needs to be prejudicing to the adverse party, or the party needs to demonstrate that the other party who sat on their hands acquiesced to not seeking the enforcement of that judgment. And in this case, the court noted that the trial court, while properly finding that latches did apply, did essentially engaged in some bootstrapping between those elements and found the delay equal to prejudice, and the Court of Appeals took issue with the factual findings more so and related back to for further litigation. But I think the most important part of this case is understanding that these defenses do exist, and it's a good counterpoint to what we heard about collecting against copyrights and the ERISA not being a defense to using Quadro for enforcement. We've seen in previous years wide-ranging enforcement of support orders. So this seems to be a really interesting, and the Court of Appeals even calls it a novel legal question as to what defenses exist in this context. Definitely a worthwhile read.
All right. Thank you all. We've run out of time. If the bar will forward questions to us, we'll do our best to answer them. Thank you all for being with us. It was our pleasure. And be well. Take care.